We're with David Shapiro. David is a criminal defense attorney in San Diego, California. He's agreed to answer an online question that was posted related to stalking. With that said, David, here was the question. The question was from Bobby. He said, I sent a bunch of emails to an old girlfriend. I wanted to get back together, but I had made come on a little strong. She says I was harassing her and that she felt threatened. Now I'm facing a California stalking charge. I have never intended to hurt her. So how can I be convicted of anything?
Well, hopefully, Bobby, you don't wind up getting convicted of anything. That's ultimately the goal, as I'm sure you're well aware. But what we're dealing with when charged with the stalking offense, that leads me to believe there was a series of email over a series of time, which intended to be they would need to prove that it was harassing in nature, repeatedly harassing in nature, and at some point there was a credible threat made. Whether or not you felt like you were going to follow through with it, whether or not you had the reasonable ability to follow through with it, at some point they would need to prove that there was a threat made and that she or her immediate family was reasonable to be in danger or to fear that their lives or well-being or property or what have you would be in danger. So, what would be important in analyzing a case like this would be to go through the emails to get a dynamic of the relationship between the two of you. Was it uncommon to send that many emails to her? How uncommon was it to send that many emails to her if it was uncommon? The exact language, what she knew of you, what you knew of her, all of those factors to basically show to the prosecution and to a jury if the case ultimately makes its way to trial that, show them the full picture, not just a couple of isolated emails where someone may look at it and say, wow, this guy's out of line. This may be harassment. This may be stalking. To show them the full picture, the full body of work, and how, this at worst would be an isolated incident. From what you're telling me, if it's not that bad, I think her remedy may be better off filing a civil restraining order as opposed for the prosecution, the district attorney, or the city attorney to file criminal charges. But the concern with these stalking cases is, one, if you're accused of stalking when you're under a protective order, meaning if you're the party that can't go near someone. So if she had a protective order against you and then you're accused of stalking her, the penalties could go through the roof as far as what type of jail time. Is it misdemeanor, felony, fines, all those types of things. That's something that certainly gets factored in as well as whether or not you have a prior criminal history. All that could factor into how seriously these stalking cases are being taken, particularly if you have a criminal history involving threats. So, the goal of any case is obviously to avoid getting charged. Once you're charged, to avoid getting convicted. Stalking is no different, but it is a pretty unique charge. So you want to make sure you consult with and have, if you don't have already, an attorney who has experience defending against those types of cases, both in a civil domestic violence restraining order context as well as in criminal court.
Excellent. Well, if you have any other questions for David, just post them in the comments section below the video, and he's agreed to answer those questions online. Thanks for your time, David.
My pleasure. Again, 619-295-3555. I can be reached as well. Thank you.